Ukraine approached the International Court of Justice alleging that Russia invaded Ukraine because Ukraine was carrying out a genocide against civilians with Russian roots, that too on Ukrainian soil. So, Ukraine petitioned the court to order an end to this Russian offensive, arguing that Russian reasons are nothing but a ball of lie. And after arguments, the International Court of Justice ordered Russia to stop its military action. It all looks too good and simple to be true. Like, if your country is under attack, all you need to do is approach the International Court of Justice, and this court's decree becomes the highest command, and that this decree would end the war. Is this what it takes to end a war? Of course not. Then why did Ukraine approach the International Court of Justice? I would say the answer is hope and vindication. And as long as I don't find answer to one other question, I'd also say Ukraine's move is impractical. Listen to this episode to come to your own conclusions on the International Court of Justice and its quote-unquote serviceability. You're listening to The Fundamental Rights, and this is your host, Naren Rudra. See, international interests of all the countries is peace and certainty. In fact, all the countries aspire for peace, stability, and certainty because significant affairs of each country are very closely intertwined with that of other countries. So much so that a small snag at one juncture at any remote country is enough to crumble down regional economies. And no one knows where it'll end. For example, Russia supplies 10% of world's oil. And with the ongoing war and sanctions, that supply chain is disrupted. And Ukraine supplies 50% of world's neon. It's used in computer chips. And as of today, we have only enough reserves to manufacture chips for 2 more months. Then Ukraine and Russia supply 30% of world's wheat. So now with the war, the supply of all these things is very uncertain. It's unstable. Remember, no one likes, especially the government, likes instability and uncertainty. So, whenever a war is going on, some powerful tension is loaded in the air and uncertainty looms large over the world. All the countries go on full alert and they start hedging themselves against potential chaos, financial and humanitarian. They shift their focus from being productive to just being alive. So, all of their priorities change, and it's bad for the economy and people, especially innocent people. So, to avoid or minimize these instabilities, the Hague Peace Conferences were organized and promoted by Russia's Nicholas II. He invited all the major powerful countries to these conferences to secure peace with minimal hostilities and through disarmament. Because by this time in 1899, the world was reasonably interdependent. The countries, especially the powerful ones, realized how the war adversely affects them, even when they're not participants of that war, because warring countries start blocking close by seas, which affects global trade, and then they start shooting down any aircraft that flies close to its skies. And all of this creates tension in that region. It creates instability in that region. And then neighboring countries go on full alert because refugee inflow starts. And this exodus again creates domestic law and order issues. And then because of these refugees, the crimes go up. Because when someone has nothing to lose, they'll do anything just to stay alive. And it never stops. It's like a chain reaction. And no one knows what the consequences are. And the governments hate it when anything is unstable and when things are not under their tight control. So, Nicholas II, leading the Soviet nation, proposed international peace conferences in The Hague in 1899 and then another one in 1907. Why in The Hague? Because Netherlands was one of those countries that were war neutral and it supported neither factions in any wars. So they founded a neutral venue. So this was the first time, in these conferences, when a formal international code was broadly agreed by most of the powerful countries. And since most of the world was governed by these powerful countries, mostly through colonies, This event was exceptional. It was significant because it ensured that the conventions would strictly be upheld and followed, because all the powerful countries came to a shared understanding on how to deal with international peace and conflicts. And since all deliberated and agreed to these protocols, these conventions, there was no reason for them to not follow these conventions. And again, every country had its own vested interest, and every country wanted to secure their civilians against humanitarian and economic hardships. So, the international diplomacy and traditions that we follow now were formalized and given a lot of thrust with these conferences. To resolve disputes between nations, the conference provided a judicial forum called Permanent Court of Arbitration, where parties consent and get their issues resolved. And this was the first step of creating an international forum that most of the countries actually valued and regarded with high esteem. And later, when the League of Nations was created with the aim to avoid another world war, after the first one, of course, they set up the Permanent Court of International Justice. And this court was housed in the same building as the Permanent Court of Arbitration, in a building called the Peace Palace in The Hague. It's a very charming building. You should take a look at it. And this League of Nations was like the United Nations between World War One and Two, and it failed to prevent the World War Two, very miserably. And post World War II, most of the colonies got their independence and they became sovereign nations. So all these countries continued following the international conventions and traditions and laws followed by the colonizers, because that seemed like the best thing to do with. There was literally no harm for them to follow it. And the United Nations replaced the League of Nations after World War II. So this Permanent Court of International Justice got a makeover, and it was called the International Court of Justice. And this International Court of Justice is still in the same building, the Peace Palace. Now, International Court of Justice and the Permanent Court of Arbitration differ significantly. In the Permanent Court of Arbitration, even companies and other entities can sue countries and vice versa. And in the International Court of Justice, it's just between United Nations member countries. In the Permanent Court of Arbitration, parties pick the panel of judges, that too on a case-by-case basis. And parties also get to pick the law that is to be applied and where the proceedings could be held. But with the International Court of Justice, you lose them all, because this International Court of Justice gets to pick what law it applies and where it sits. So that is it. And from now on, I'd be referring to the International Court of Justice as just the court when the context permits. So this International Court of Justice is the successor to the Permanent Court of International Justice. And it took the shape of International Court of Justice in 1945 by the United Nations Charter. And it began its operation the next year. And it is one of United Nations' 6 principal organs. And it's the United Nations' sole judicial body. And the court is made up of 15 justices who are elected by the United Nations General Assembly and also the United Nations Security Council. And each of the judge has a 9-year tenure, and no 2 judges shall be of the same country. That is, at one time, a country can't send 2 of the judges on the panel. And this may seem a little strange to us, but in a lot of other countries, especially in the United States, judges too require votes of their Congress. So voting of judges in the United Nations is only new to us in India. Then in the court, judges exercise their duties in their independent capacity and not as a representative of a country, although their origin countries extensively lobby to get their judge elected to the panel. And all of the United Nations Security Council countries, US, Russia, France, UK and China, always have their judges from their countries in this panel of 15. And India's current judge is Dalveer Bhandari, who was a former Supreme Court judge. And the first Indian judge in the court was the illustrious B.N. Rao. He's the gentleman who virtually drafted the Constitution of India. Then the court had a former Chief Justice of India, Swarup Pathak, as its member. And the court also had Nagendra Singh as the president of the panel, president of the court. And Singh himself was from the civil services, and he served as a secretary to the president and then joint secretaries to crucial ministries, and then he was the chief election commissioner. And most importantly, he was also a member of the Constituent Assembly. So that'll make a lofty resume if you ask me, right? So the eligibility to become a judge of the International Court of Justice is to be eligible to become the judge of the highest court in that country where they're from. Then, if two countries appear before the court, if none of the judges are from these litigant countries, either country can request the court to include in the panel a judge from their own country, so that in case of any queries on local laws, this new judge could enlighten the panel. So, the strength of the panel could go up to 17 at the most. Now, on the theoretical side, in international law, all the countries are equals, irrespective of their size, economy, population, any variable. They're neither superior nor inferior to other countries. They're equal. And each country is sovereign, like there's no country above them. And each country can take its own decisions independently as opposed to colonies. So, this court, which is a creature of an organization comprising of all the equal countries, obviously will have no claim of jurisdiction over any country, that too as a matter of right, because the court itself is a creature of an assembly of countries. So it's no surprise that countries don't have to and they don't want to subject themselves to jurisdiction of another entity for the reasons of self-interest. And it also defies logic because to be recognized as a country itself requires it to be an absolutely sovereign nation. And if this sovereign country could be forcefully subjected to a jurisdiction of another entity, and in this case the International Court of Justice, it would no longer be sovereign. So, the fundamental and rudimentary principle of adjudicating disputes between countries is consent. The International Court of Justice cannot take up cases without consent of both the litigant countries. It just cannot. It's not a super court that sits above all the supreme courts of all the countries, because countries are sovereign entities. And unless both the countries knock at the doors of the court and consent to the judicial process of the court cannot take up an issue. And here too, the court can only adjudicate on issues that both the parties consent to. So, if there are 5 issues in one case and one country consents to all 5 issues and the second country only for 2 issues, the court can only adjudicate for 2 issues. This is how paramount consent is. And another part of the reason why consent is this crucial is that the court has no mechanism to enforce these decisions. The court has no international police force under its control. There's no such thing as international police force. So it just rests on the goodwill of the countries to enforce the award. And more on this a little later. So in most of the cases, countries know beforehand whether they're at fault or not. And they don't consent to the court's jurisdiction if they know that they're at fault. So there's nothing astounding about it. So most of the cases that come before the court are cases arising out of violation of a treaty to which both the litigant countries are signatories. And in these treaties, the countries consent while ratifying them to be subjugated under the court's jurisdiction or any other body. But if the treaty is administered by the United Nations, the treaty includes the International Court of Justice as the judicial forum. Then again, all the countries could refuse to consent and opt to give consent on a case-by-case basis. And if the countries know that they can't follow through the treaty, they choose this optional case-by-case protocol. And this is often called the special agreement. So that's that about the court's jurisdiction. Now, in this case, both Russia and Ukraine are parties to 1948 Convention on Prevention and Punishment of the Crime of Genocide. The object of this convention is to suppress and prevent genocide. Article 9 of this convention empowers a ratified country to petition the International Court of Justice on any interpretation and violations of the convention. Now, both Russia and Ukraine are parties to this convention, and Russia, while ratifying it, consented to this court's jurisdiction. So, this court's jurisdiction extends to the scope of this treaty, because Russia claimed Ukraine violated this treaty by committing genocide. Despite making this claim, Russia did not show up for the hearing. And there's no way to drag Russia into the court because, despite countries giving consent to subject itself before the court, there's no enforcing mechanism. The court can't forcefully bring Russia before it because Russia is a sovereign country. So, even though a country consented, it's entirely based on the country's goodwill, and Russia seems to be lacking that goodwill, that obligation. So, Ukraine argued before the court that Russia's allegations that Ukraine has committed a genocide against Russian origin citizens in Ukraine is false. And since Russia's allegations are unfounded, its use of military force to prevent this non existent genocide is violative of international law. And since Russia is making the genocide allegations, Russia's interpretation of what genocide is in dispute. And under Article 9 of the 1948 Convention, the court has the right to adjudicate on this interpretation. So, Ukraine requested the court to pass provisional orders against Russia to stop them from using military force. And Russia didn't even attend the hearing, it just sent written submissions. And in those submissions, Russia argued that genocide also exists outside the scope of this 1948 convention. And this allegation is just one of those claims which cannot be traced to the 1948 convention. It is outside this convention. And nowhere did Russia claim that Ukraine violated the 1948 convention. These were the arguments of Russia. And Russia said it merely said Ukraine committed a genocide. Russia then argued genocide convention is not even remotely related to the use of force between states. And use of force is regulated by the United Nations Charter and customary international law. So, to read into these conventions, these aspects of use of force and all these other things would be to unduly inflate and distort the object and purpose of the convention. And Russia has invoked the Article 51, which gives a country right to self-defense. And Russia, in fact, submitted a resolution under Article 51 before the United Nations Security Council. And these were the end of Russia's arguments. So, if you ask me, Ukraine's case is entirely hinged on a technicality. Now, as a provisional measure, the International Court of Justice has ordered Russia to stop the military action, and the court held that Ukraine didn't commit any genocide. So, in effect, Russia's use of force is unlawful. Now, what if Russia says to hell with the court's order? I'll do whatever I want to, I'll keep on going attacking Ukraine, I'll keep on bombing their buildings. What will you do? Nothing, because the International Court of Justice can't do anything. It is basically powerless. The most Ukraine could do is go to the United Nations Security Council and slam on their table this court's order and ask them to enforce the decree, because it is this council that enforces any decrees, any resolution of the United Nations. Then Ukraine would be at the mercy of this council's decision for its enforcement. Now, here too, Russia is a member of this permanent council, so it has the all-powerful veto power. So, Russia could easily use this veto to stop even discussion of this court's order, much less the enforcement of this order. So, Ukraine will have nothing to do. And this is also what America has done a few years ago when a judgment was passed against it by the same court, where America used its veto and got its way done. Now, here the United Nations Security Council would be moderately, obligated to enforce it, because all the member countries have at least one judge from their countries in the panel. So here too, the countries could argue that the judges are functioning on their independent capacity and not as a country's representative. So they can argue that it's the opinion of an individual and not of a country's official stand, if questioned on the collegiality of members of the same country. Now, even if Russia doesn't veto the enforcement application, the Security Council could still refuse to intervene because it is a discretionary power of the Council. Then the only option would be a military conflict, and no country wants that because it's extremely expensive, and the cons of engaging in a military conflict outweighs the pros by a long shot. So Ukraine has no way to enforce its order. The only upshot of the judgment of this court is vindication. And it only approached the International Court of Justice with the hope that it'll win the case, and also with the hope that the Security Council might enforce the judgment. Nothing more, nothing less. And that's why the court is often referred to as a toothless bulldog. And it's true because it can't enforce its decisions, and this court order would only be good for an academic discussion because it has no enforcing power. It's not binding on it's not binding on the Russian Federation. So the only authority it has is that this judgment, this court order, is a product of 15 high level judges from 15 different countries, and nothing more than that. So, the one unanswered question I have is, why did Ukraine approach the International Court of Justice despite knowing that the court can't enforce its orders? And this is why I find Ukraine's decision to approach the court impractical, like I said in the introduction. So, in a sense, despite Ukraine winning the case, it can't enforce the judgment. So, Russia could not be stopped by the court. The only way Russia is facing the music is with the economic sanctions, and those too will slowly and steadily be lifted by all the countries because Russia invaded Georgia sometime in the early 2000s, and countries imposed sanctions. It still grew, its size grew, and Russia invaded Crimea. Countries then imposed sanctions. It still grew, and by the time they attacked Ukraine, almost all of the sanctions were lifted. Now Russia invaded Ukraine and countries imposed sanctions yet another time. So I think this time it'll be no different. The only thing that will be different is your understanding of the International Court of Justice and its effectiveness because you listen to this episode. So this is almost the end of the episode. And one interesting thing is that the petitions filed before the Permanent Court of Arbitration and this International Court of Justice have a format similar to the ones we have in the moot courts. So, although all of these formats look alien to us Indians, this format is widely used internationally. And another important issue is the International Criminal Court. And this court could try, all the war crimes and crimes against humanity. And even this court is practically a joke because the major countries that are party to this criminal court are the European Union and Australia and Canada. And the three big belligerent countries, Russia, China, and America, are not even signatories to this one. And neither are India and Pakistan. So if this case reaches this International Criminal Court, I'll make another episode maybe on International Criminal Court and how useless it is again. So that's it for this episode. Stay tuned, and the next episode will be on the Karnataka High Court upholding the hijab ban. This is Naren Rudra signing off.